My name is Patrick Hirsch. I am a partner in the Project Finance Department of Bowman Gilfillan. Mining projects are often funded by way of limited recourse project financing. What this means is that the bulk of the financing for the development of the mine does not come from the company that holds the mining right itself, nor does it come from the shareholders of that company, but rather from third-party lenders. These third-party lenders will usually want to ensure that they have first-ranking security in the form of a pledge over the shares of the company that holds the mining right, and also a mortgage bond over the mining right itself. In this regard, the Mineral and Petroleum Resources Development Act presents certain challenges. Section 11 of the Act prohibits the pledging of a controlling interest in a company that holds a mining right without the written consent of the Minister of Mineral Resources. There is an exemption that applies in respect of listed companies, but often even where the ultimate parent company is a listed company, the mining right itself is housed in a subsidiary which is not listed, and therefore this exemption will not apply. Furthermore, Section 11 prohibits the granting of a mortgage bond over a mining right without the consent of the Minister. Again, there is an exemption. The exemption is in respect of a mortgage bond which is granted for the purpose of obtaining a loan from a South African bank for the purpose of funding a mining project. However, for a number of reasons, the security package in financing transactions of this nature is often such that the security is not given directly to the lender themselves, but rather to a special purpose security company that has been established for the sole purpose of holding that security. It is not clear in these cases whether the exemption will apply. In addition, if the security is to be realized and the pledged shares are to be disposed of, or the mining right is to be disposed of, pursuant to the security, a further consent from the Minister will be required at that stage. Probably of greatest concern, however, is Section 56 of the Act. Section 56 provides that the mining right will lapse if the holder of the mining right is liquidated, unless there is a mortgage bond over the mining right to which the exemption in Section 11 applies. Clearly, you can see that this will present problems for the lenders in many cases, as the mortgage bond over the mining right will be of no use if the mining right itself has lapsed. This rather unsatisfactory situation will require either legislative reform or commercially expedient, if somewhat creative, interpretation of Section 56 by our courts.